Hello, I'm Rebecca Weber. You're listening to AMAC's podcast, Better for America. AMAC's national spokesman, Bobby Charles, is back with us today. This is the Reb and Rob Show. Bobby, welcome.
It is great to be back, Rebecca. Boy, we live in these consequential times, and being able to update now and again is nice.
It is really good, important. Bobby, I so enjoy these conversations, and we certainly have a lot to talk about today. Now, you've spent time in all three branches of government, and sometimes I think that 360-degree perspective is so valuable. We see so many things happening today that we've never seen before. So today, I wanted to focus on one issue, different perspectives on this one issue. I think that we're all seeing, as never before, our judicial system being overtaken by politics, in particular the left infiltrating the judicial branch. So I wanted to peel that back and talk a little bit about what is happening, what it means, where it's going, and what we can do about it. Now, we see a terribly partisan Democrat who serves as Maine's Secretary of State, selected by Maine's Democrat legislature, who has just decided, Bobby, all by herself, that Trump was part of an insurrection. And while she's not a lawyer, she talks about the 14th Amendment, and she says she can kick him off the ballot for being an insurrectionist. This is blocking the top Republican from the ballot. And then, of course, in Colorado, you have 7 anti-Trump Democrats on their high court. That's splitting 4-3, and they're trying to kick Trump off the ballot as well. Let me ask you this. Is there any legal argument for these decisions, and what are the implications if this kind of anti-Democrat behavior is allowed to stand?
You know, Rebecca, this is such a good sort of pinpoint example of what has gone wrong when it comes to the fair administration of justice. The short answer to your question is no, there is no legal argument, and it's very straightforward. The 14th Amendment, which incidentally has other articles in it that sort of vitiate or sidetrack, which has other sections that sidetrack Section 3. But Section 3 was designed specifically to prevent Confederate officers from becoming part of the government after the Civil War. There is absolutely no question that the purpose of that was all directed at that moment. And there are other aspects of the 14th Amendment and the 13th that are very important post-Civil War. But that provision was designed to keep any of the Confederate officers who had killed some 620,000 Americans from ever reaching government again. That's the only purpose that was framed for. But let's go a step further. Even if you imagine that they were thinking ahead and they wanted to prevent some future civil war and they were going to block it all out again, the notion of an insurrection was never defined, and it really essentially amounts to an operational definition of the United States Civil War. But let's go and see what does an insurrection mean. There is no adjudication right now of what an insurrection means by the Supreme Court or by any federal court. And so now we have to go to the operational question legally. Are there other cases that have been brought? We had 120,000 people on the mall. You had about upwards of 700 who got involved in this riot at the Capitol. Many of them were arrested. Have any of them been charged with insurrection? And the answer is no. Not one of them has been charged with insurrection. And the reason is that the prosecutors, if not the judges, know that insurrection would not hold as a charge. So now we have, on the flip side, a president at the time who is no longer a candidate. The election is over. He is now giving a speech encouraging people to voice their mind safely, peacefully on the mall. And what do we get? As, by the way, has happened thousands of times before. Is that or is that not an official act? Ultimately, it should be considered an official act because it was an act by the President of the United States, written in the White House, et cetera, all of which is to say he has immunity from prosecution anyway. But the bottom line, Rebecca, is that Secretary of State in Maine and that Colorado court have allowed politics to wag the dog. And the sad part is it affects the franchise, the voting rights of everyone in the state of Maine and in the state of Colorado. And in the event that somehow, and this will be by the Supreme Court, this will be resolved and thrown out. But if for some reason it wasn't, what you would see is essentially an unarmed civil war, because there are 25, 26 states preparing right now to consider throwing Biden off the ballot for reasons that have to do with alleged or to put it this way, there are legal scholars that say that they could be throwing Biden off the ballot for alleged crimes or for dementia or for any other subjective reason, and you would end up seeing half the states voting on one set of candidates and the other half voting on the other set. It would be chaos. So we're not going to let that happen. There is no good
Total
legal argument
chaos.
for it.
And the American people know that the real insurrection is occurring at our southern border, our northern border for that fact. I mean, we saw that so many people turned out in Maine, in New Hampshire rather, just a few days ago. And certainly, their major concern was this wide open border. Joe Biden ought to be held accountable for what's happening, these massive number of illegals, very dangerous people, many of them. That's the real insurrection in my view. And of course, we don't see the full picture. The January 6th tapes, there's a lot left to that we don't know about. So the American people are wise. They're smart. They're not falling for this. And I wonder at times how these people, these partisan actors, can't see how off base they are. I mean, let me turn to another way the judicial system is being twisted. This is how the D.C. court is behaving. Now, you've recently written on how the important D.C. appellate court is partisan, transparently and politically anti-Trump, first on presidential immunity, and then using a backdoor to get what should be protected, and that's presidential records, and then gagging Trump as he runs for president. So that court blocks Trump from exercising his First Amendment right to say that he's mistreated by Biden's Justice Department. Bobby, is that right?
No. It's absolutely wrong, Rebecca. And you've pointed out something here that actually is occurring in other circuits as well. But DC is sort of the poster child for how partisan, transparent, as you say, really just sort of obvious politics have infected that very important appellate court in Washington, D.C. So the three cases you mentioned, the immunity case is similar to what I mentioned a minute ago. This is a case in which the court basically rubber stamped a very partisan district court judge who had said that it was not an official act, that the president's speech was not an official act, or that they wouldn't agree that it was an official act. And so they sent it back down to the district court to have more adjudication, more interference in this campaign, to make Trump defend himself again as a president. Well, I don't know how much more defense you can get other than he was a president giving a speech, which has always been a protected act. But that having been said, that was case number one. Case number two was the case that they decided that you just mentioned, in which it was an 7-4 decision. And it brought me back. The reason I wrote about that one is it brought me back to the period in 2018 when Donald Trump said, look, I'm trying to protect the border. And there's a district judge who just put out this is 2018. He said, there's a district judge that just put out a big order and said that I can't take these actions as a president to protect the border. And he said that was an Obama judge. So Justice Roberts, who has recently distinguished himself again for not being conservative on the high court, but Justice Roberts said, hey, stop calling. He rebuked the president at that time in 2018. And he said, stop calling them Obama judges. We're all nonpartisan judges. We're all noble people, blah, blah, blah. And so Trump, basically was in a corner. Now, wind the clock ahead. And what happens repeatedly now on these circuit courts, and what's happening on the D.C. Circuit Court? Not only did you have that immunity decision that was all Obama-Biden judges against Trump, now you have the second big decision. And what do they say? They say 7 judges on one hand and 4 on the other. Let's put 2 more over here. 7-4. They say, with 4 Obama judges and 3 Biden judges, they say it is permissible for the federal prosecutor, Jack Smith, to go around behind the back of a president to secretly go to the servers of a major high-tech company, grab all the presidential emails and tweets and everything else, and take them over here. And before he even has a chance to say, wait, there's executive privilege. You can't just take presidential emails out of a server. Well, incredibly, in this 7-4 decision, the D.C. Circuit says, oh yeah, we'll just let that rogue federal prosecutor take all of that stuff out of the server. No executive privilege asserted. Here's the real kicker. In that decision, the 7 Obama and Biden judges wrote no opinion. They just let it happen. The 4 who had been appointed by Bush or Trump, who are judicial conservatives, said, no, this does not fit the way that the Constitution has always been interpreted. We cannot just walk all over the Constitution and say that because you want to get this guy, he doesn't have any executive privilege. So that was case number 2. Case number 3 just happened, and they basically, DC Circuit said you can gag a presidential candidate if he's being sued. What kind of baloney is that? I mean, to me, that is the very definition of election interference. When you have, again, Obama, Biden judges saying the leading Republican is not allowed to speak about an injustice being perpetrated by him, on him, by an attorney general from this president who's also running against him. To me, it is a distortion of the first order. And I think, Rebecca, to the theme of today, it goes to show you in a very objective way that the justice system, and even up to and including our judiciary, has been penetrated, at least in places, by pure partisans. And this is the end. I saw this all over the world. I saw this happen in Bolivia, in Colombia, in Kosovo. I saw it happen in Iraq. I saw it happen in countries that Turkey, places. Basically, what happens is a powerful executive literally rips the independence out of the judiciary and makes it an organ of their political party. We cannot let that happen in this country.
Not here in America, certainly not. So we've
No.
got these Obama and Biden judges who are pouncing on Trump, saying his January 6th presidential speech was not an official act. And then we've got Jack Smith, as you just said, who is forgetting executive privilege and getting secret communications from social media servers. Now the gag order, and of course Justice Roberts, who says that there are no partisan judges. I mean, this is insane what we're hearing. That certainly gives us a fresh and sobering perspective, I think, on really what's happening. Hopefully the future will produce a federal bench that is more faithful to the founders' intent and our Constitution versus their own political whims. But Bobby, I want to turn to another issue that involves due process, rule of law, and where we see both completely trashed by partisan Democrats. Tell us what we're learning from the work of government oversight, these investigators, and in particular about how due process was or was not followed by this much talked about January 6th committee that Democrats threw together to impeach Trump.
Absolutely. Rebecca, when at first, what is it, Shakespeare's quote that I will forget? When at first we do deceive, the web we weave, etc. The Democrats have pushed down this partisan path, and they have, yes, at the judicial level and with prosecutors, they have violated rule of law principles that have been around for 200 years. However, actually longer than that. However, this is a classic example of the extension of that same principle. And I think a lot of Americans, when they saw that sort of snap impeachment at the end of the Trump term, they said, gosh, this just doesn't seem right. I mean, how can you just automatically say that, a few days before that, there had been this January 6th riot, and now we're going to just impeach a president in a matter before he can even get out of office. I mean, he's leaving office, and you're still going to impeach him. And so it seemed as if they had violated due process. Now what we're finding on the hard facts, which the January 6th committee, basically you have now 3 committees investigating what's going on. And the biggest one is the chairman of the administrative committee, which is Chairman Loudermilk. And he is coming up with data, really hard and fast data, that show several things that are really disturbing to me as a lawyer, should be disturbing to every American. The first is they destroyed something like 100 files. They were initially encrypted files, so they were very important files used in that January 6th investigation. They destroyed that real evidence. The Democrats destroyed it the day before they handed the committee gavel over to the Republicans. The second thing is they handed a lot of data back to the White House so that it could be protected by the White House, even though it was depositions and in interviews that had been done by Congress. So a complete violation of separation of powers. They took things that belonged to Congress, and in order to hide them from Republicans, they stuck them over here in the White House. The White House then redacted and apparently lost a lot of those files. But the third thing is we're finding that of the files we've been able to retrieve and see and look at, the investigators on the Hill have found out that there is exculpatory evidence in there. That is to say, evidence that shows that the people who were being prosecuted as January 6th rioters, many of them were actually had defenses that they were unable to raise because the evidence had been held back by Congress. Now, when we go to trial, and, as a former litigator, I can tell you when we go to trial, you have a prosecutor is required to disgorge, they call it, Brady evidence or Jenks evidence. This is evidence that the prosecutor stumbles on that shows that the defendant actually may be innocent. You are required, as a matter of constitutional law, and case law to produce that evidence. What did the Democrats do? They took that evidence, they hid it, they destroyed it, and they didn't produce it. So I would argue to you that that in and of itself looks an awful lot like interference with rule of law. It looks to me like there are potential statutes that these people violated. Never mind, I am told that Liz Cheney, that self self-congratulatory former member of Congress who apparently was thrown out on her ear by the Wyoming voters, that she actually sat in on almost every deposition and every interview and played a very intimidating role, seemingly trying to get people to change their testimony in the middle of this. What does that do? It changes the whole narrative about January 6th. That committee was not a committee dedicated to finding truth. It was a dedicated committee dedicated to framing Trump. That's what they were all about.
And she
And when you
said it.
now find exculpatory evidence, what does that mean for all these people who have
Right.
been held behind bars and who have had no chance even to get themselves to trial? So I think we've got a lot more to learn about this, Rebecca, and I just am grateful that there are some courageous Republicans on the Hill, like Congressman Loudermilk, who are out there saying, wait a minute, this is not right. We don't do this in America. We have due process in America. So I guess in the months ahead, we find more and more of that due process.
Americans see this as illegal election interference, and this is what you've mentioned. Do you think any of these cases will affect Trump's political fortunes? In other words, does the apparent unfairness of them even matter? Where do you think this is headed, and how might this impact Trump as our future president?
Yeah. Well, let's look at that and sort of take it in two blocks. Block one is what is the immediate political impact of some of these cases that they have brought against Trump after the impeachment. You have the one in Georgia, you have the one in New York, you have these two that have been brought by Jack Smith. I'll tell you, first off, there are so many constitutional problems with all of those cases that I think it's very likely that one or all will reach the Supreme Court and just be thrown out. You also now have really significant partisan issues and appeal issues in the New York case. You also have misbehavior by the prosecutor in the Georgia case. And you have these cases that look thinner and thinner that Jack Smith has been trying to bring about classified documents, which is rather ironic because more classified documents were withheld by Biden than were ever withheld by Trump. And you have this January 6th issue, which I think is increasingly thin. I mean, at the end of the day, there's no there. So if no one was ever indicted for insurrection, how can a speech be called a basis for insurrection? So all of those cases legally I think, are on a path to being resolved on their constitutional merits by the Supreme Court, either directly or indirectly. The second thing I'll say is the political impact reminds me that there are often cases in physics that relate to human nature. And I'm always intrigued that the laws of God play out in different ways, but by God, they sometimes are very similar. And so you have a thing in physics called ground effect. And that is, an example of that might be if you have a helicopter in a canyon, the further you push the throttle up, the more the vortex pushes that helicopter down because of the side effects and the down effects of the throttle. So what are the Democrats doing? They're full throttling up in order to destroy Trump. But the irony is there's a ground effect. It is destroying their own campaign in the process and raising Trump because people hate unfairness. Americans love freedom and they hate unfairness. And if you ask, why did Trump just walk away with Iowa? Why did he just walk away with New Hampshire, given all these cases? You have to actually go back to the origin and say, not only were the policies ones that Americans wanted, and they don't want Biden, and they do want authenticity, and they do want someone who's been at the helm, it appears. But it's more than that. It's that they think he's being treated unfairly. Joe Biden has made Donald Trump a very sympathetic character. And the last thing I'll just say in terms of legality, not just on those cases and those prosecutors, but perhaps even with the January 6th folks, all of this looks a lot like election interference. And there are federal statutes. I encourage people to Google 18 USC 595 to 610. Those are all the statutory provisions at the federal level, and there are state ones as well, that say if you, even as a prosecutor, even as an administrator, even as someone who's within the government, if you interfere knowingly with an election, and it includes an election for president, you are putting yourself in a position where you may face inquiry for liability for election interference. And I think downstream, we're going to look at this and say this was a really ugly period in American history. Thank God there were people who still believed in rule of law and fought for it. And thank God there were still idealists out there who say, you know, I want my country to be the best it can be. It's not about a man. It's not about an individual election. It's about rule of law, and it's about our founders' founding principles.
You know, the left, it seems, is going to stop at nothing, Bobby. They want to, they'll stop at nothing to try to take Trump down. And we've heard it from so many people, the likes of Liz Cheney, who said, my goal is to make sure that he never can run for political office ever again. So, you know, she's motivated by evil acts, in my view. This is unfair to the American people, and you certainly bring a bird's eye view, that 360-degree view on so many of these issues. So I really appreciate that. Bobby, you know, I love that we always wrap with some positivity, but before I move on to my final question, I have to mention what we just saw come out of the Supreme Court, that is allowing Texas to cut this wire, this razor wire. American people, we just had our boot camp for boomers recently, and you know, our AMAC members, here's what they said. They said, why aren't the men of Texas and people like us, why can't we just go down there and lock arms and just be human shields, you know, protecting the border and preventing illegal drugs, illicit drugs, child trafficking, human trafficking? I mean, you know, Americans see that this is such a bigger problem. The left doesn't want movies like Sound of Freedom out there. They certainly are afraid that if people wise up to see just how vulnerable we are making our neighborhoods, our cities, our towns. But what really made me scratch my head and pause was why, in your opinion, did the Supreme Court rule that way?
Yeah.
And should
So
Texas ignore it?
Well, they may. Let me summarize it. You have 9 justices on the court. That was a 5-4 decision. I would have thought that Barrett would have gone with the conservatives, and she didn't. That would have made it 5-4 the other way. I've begun to lose faith in Roberts being a judicial conservative, because I really think he tends toward the other direction and has since that Obama decision way back, Obamacare decision. What happened here, conflicts of laws has to do with federal priorities and prerogatives under the Constitution and state prerogatives. And what the founders did is they said, we really believe in states having their own sovereignty. They have their own rights to protect their own people. We have a very limited area here where we're going to give the federal government some authority. We're going to give them authority in the Commerce Clause and in the Supremacy Clause, that under very limited circumstances, their sovereignty at the federal level to hold us together as a union can trump states' rights. And what people need to think about, Rebecca, is the 10th Amendment. And our founders were very wise. They put this amendment in, and anybody can go quickly look it up. We don't talk about it a lot, but what it says is anything that is not written down in the text of the Constitution as a right that goes to the federal government belongs to the states and to the people. And what happened after the Civil War is people said, and a lot of activist judges in the last century said, look, the 14th Amendment, which is an equal protection related amendment and due process amendment, essentially applying equal protection and due process down to the states, because after the Civil War, everybody needed to be protected by the states as well as by the federal government. That kind of gobbles up the 10th Amendment. Well, that's not really true. That's not really true. The 10th Amendment is as true today as it ever was. And I think what's going to happen is people are going to go back and say this Texas case illustrates to us that what it illustrates to us is that states are very upset when the federal government fails to do the thing it's supposed to do to protect us. And we're going to protect ourselves. Now, I will give a little bit of hope on this. On the one hand, it essentially had to do with cutting concertina wire to be able to get to the Rio Grande River, and it does create a conflict between the federal government and the state government. I think there will be an accommodation. I think what will happen is the Texas Rangers do not want to be fighting with the American National Guard that's been mobilized by a president to go cut wire. So what will end up happening is that they will make an accommodation and say, look, if you think we're going to keep some wire up here, but if you think that you need to go in and you need to rescue someone, we'll certainly have somebody there to help you go rescue them. It'll be an accommodation on this case. The only thing that I think is a silver lining here, and I am not a guy that likes a lot of federal power. I like limited government, diffused power. I'm very suspicious of concentrated power. I do not like the fact that the federal judiciary would come down in favor of the federal government over the states. However, if Donald Trump or a conservative Republican becomes the next president and he says, we must protect the southern border, and California, never mind maybe Arizona and New Mexico, say, no, we're not going to pay any attention to you. We're going to keep waving illegals in. You have no right. Well, then they can go back to this decision and they can say, no, 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 no. We have an obligation to protect the American people. And if you won't do it as a state, we will do it as a federal government. So there is a little bit of a silver lining.
That's very interesting, very interesting. Bobby, before we wrap, I know you were a U.S. Court of Appeals clerk, Ninth Circuit, and that was when Justice Kennedy was on that court. Have you ever spent time with any of the Supreme Court justices? Do you have any impressions about them?
Well, it's funny you should ask that because I did not clerk at the Supreme Court, but by good fortune, I have spent a couple of hours with different justices. And in particular, I had some good private time, really 2-on-2 with Justice Alito for about an hour. And I also had time at one point, maybe 5 or 6 on one with Justice Thomas. I sat down with Justice Alito and his wife, and it was a fascinating conversation. Very human people, extremely good-natured people, very understanding of the average person, and very committed to the principles that lie in the Constitution, just intuitively able to sort of channel those founding fathers' ideas into judicially conservative thinking, which is to say they make their decisions in a way that is focused on the plain meaning of the words, the text of the Constitution or a statute, and the original intent of people who created those words. So, and then Justice Thomas, my gosh, both of these men are so smart, Rebecca. It blew me away. Justice Thomas went all the way back to the Magna Carta with decisions. Someone would ask him in this little group, a very small group in his chambers, they'd ask him a question about some principle. He would cite Montesquieu. He'd then cite a dozen cases all the way back to the Magna Carta. And he wasn't even given warning that these were issues that are going to be discussed. So I will tell you that I really miss Justice Scalia. He was probably one of the most endearing, smart, conservative, thoughtful, self-deprecating, honest people who have ever sat on that bench. But having met and spoken with Justice Alito and Justice Thomas, those men are cut from the same cloth. And I am so grateful that there are people like that on our high court.
Oh, it's just wonderful. When we conducted our Man or Woman of the Year poll, Justice Clarence Thomas actually came in second. Americans really do love the work and his focus on preserving and protecting our Constitution and interpreting it as such. So thank you again, Bobby. Just such a good note to end on, and so grateful for these insights. I'm so looking forward to the year ahead. 2024 is, I think, going to, we have a lot of hope in 2024, a lot of opportunity to right the course of America, and hopefully everyone out there agrees with us and will roll up their sleeves and get involved in the fight. Be sure to join or renew your AMAC membership. There's so much you can do right from home. When you become a part of AMAC, you can participate in AMAC Action. This is a vehicle that we've set up so that everyday average Americans have the opportunity to speak their voice. We bring your voice to Washington. We're fighting on the issues that you care most about. Thank you so much to all who are listening. Thank you for tuning in. Until next time, I'm Rebecca Weber. Have a wonderful evening, everyone. Does social engineering from leftist corporations make you feel like we're living in the Twilight Zone? If so, you're not alone, and that's why we're proud to stand behind a wireless company who stands behind your values. I'm talking about Pure Talk, an AMAC-supported wireless company on the nation's largest 5G at half the cost of the big three. So I challenge you to stand with a company who champions your values. Those of you who have always had your neighbor's back, you've pulled yourself up by your own bootstraps, and you still believe that the flag stands for freedom. It's time to join the masses who have fled their old wireless companies for something better. Pure Talk. Pure Talk gives you phenomenal coverage on America's most dependable 5G network for half the price of the other guys, with unlimited plans starting at just $20 a month. The average family saves almost $1,000 a year. And as an exclusive AMAC partner, Pure Talk will give you 3 years free on your AMAC subscription. Just dial 844-8-PURE-TALK and mention AMAC Podcast to make the switch. That's 844-8-PURE-TALK, and make sure to mention AMAC Podcast to get 3 years free on your AMAC subscription.